to a better start tonight than we were at our last forum. The microphone never works. So. Well, good evening, everyone. And just to start, I'd like to thank the Frankfort Township Democrats, the New Lenox Township Democrats for agreeing to host and organize this event. These events really are critically important for all of you, so that you have an opportunity to learn a little bit more about the two candidates, Judge O'Connell and myself, that are vying for the party's nomination in November. And I understand, I think we all do, that judicial elections aren't always considered the most interesting, they're not the most thrilling or exciting like a Senate or a congressional election, but they are so important. They are critically important, and I do think that people are beginning to realize just how important they are, especially in this time that we find ourselves in, when the very rule of law is constantly under attack. The rule of law, that concept that tells us that everyone is equal before the law, that everyone is granted equal access to justice, an equal opportunity to be heard, and guaranteed certain due process rights. And that very notion, that concept that really defines partly who we are as a nation, is under attack. So it's so important to know who our judicial candidates are and what our judges stand for, because only with good judges, good lawyers, good judicial partners, all working together with that shared commitment to the rule of law, can we begin to push back against some of these attacks, and also sort of try to restore some of the faith that our fellow citizens have lost in our system of justice over the last year. So again, these forums are important, these races are important, so thank you for being here. I don't want to spend too much time talking about my qualifications right now, because I imagine we'll have some time to do that as the night goes on. But I will say I do believe that I'm more than qualified for this position. I'm going into my 7th year on the bench as a trial court judge. During that time, I've presided over numerous courtrooms, including some of the most sensitive courtrooms that we have in the Will County Courthouse today: juvenile abuse and neglect, juvenile delinquency, guardianship, adoption, very sensitive court calls, and I'm presently on a criminal misdemeanor call. And prior to that, I spent 14 years in private practice. Focus of my practice was international human rights litigation, so that required a lot of motion practice, a lot of legal research, a lot of legal writing, a lot of appellate arguments. So I really have honed those skills, which are critical for an appellate court justice going forward. And I've argued cases briefing all the way up to the Supreme Court. And then finally, I'll just end with this. You may notice sometime tonight that maybe you'll ask a question and maybe you don't get a direct answer from me or even possibly Judge O'Connell. And the reason for that is we are somewhat restricted on the answers we can give if a case might possibly appear before us or is currently pending before us. We can't really talk about that. So I just ask, if you ask your questions tonight and perhaps you think that I'm not answering directly, do know this, that if you want to know what my beliefs are, my values are, look at the party that I've supported my entire life. I've been a Democrat since I could vote. I've supported their candidates. I've supported them with financially, as well as my vote, as well as my time volunteering. So I think the party that I've supported does reflect my values and my positions. So again, if you have to answer a question or ask a question and you're not satisfied with that answer, I think that does tell you a little bit about who I am and my belief system. So thank you again for being here and for the opportunity to speak.
All right, thank you very much. So it's a pleasure to be here tonight, and as John said, this is not our first forum, but it might be some of yours. And it is true, we are so limited because of the race that we are in as to the breadth of the questions that we can answer. But before I begin tonight, I want you to all understand that I am here tonight and I am going to do the best that I can to answer your questions and to be transparent. Initially, though, I do have to address an untruth and a rumor that has been circulated about me. It has been said, not to my face, but behind my back, that I'm not a real Democrat or that I recently became a Democrat. And I just want you to know that nothing could be further from the truth. I don't know where it came from, but I think that if anybody looked at my voting record, which anybody can do, you would see that in the past, after I moved from Cook County to DuPage County, I did pull a ballot for the other party. Moving from Cook County to DuPage County was shocking to the system. You have to understand, we didn't have Democrats on the ballot to vote for. We didn't have contested primaries. It wasn't until 2018 in DuPage County when one of our associate judges took the bold step to put herself out there and to run for election as a Democrat to become a circuit court judge. And that was someone that you all might know. That's Justice Linda Davenport. It was after that that in 2020 I ran to become a circuit court judge, and I ran from the position of just being an attorney. To label me as anything but a Democrat is, it's not fair. It neglects looking at the person that I am. It neglects the moral compass that guides me every single day. It neglects the fact that I was raised, went to Providence High School. It neglects the fact that I was raised in a strong union home by a strong union teacher who is looking down upon me right now. It ignores the actions that I have taken for myself and for my friends and for my family in order to help the women in my family not be burdened by an unwanted pregnancy. It ignores the fact that I have been a strong proponent of the Democratic women in DuPage County, and it ignores the fact that since I was elected in 2020, that we have seen a complete reversal in the sitting of our judiciary in DuPage County. I am here to tell you tonight that I am not only electable, but I am qualified. My qualifications run deep. I have been a lawyer for 34 years, and I have been practicing appellate law since I was in law school. I know that my time is up, so I will stop, and hopefully I will be able to speak more about my qualifications with one of the questions tonight. So thank you.
First question is for Justice Appellate. Over to you. This is an introductory question. It's sort of a two-part question. What does the law mean to you? And with that in mind, why are you running for appellate court at this time? And this goes to O'Connell.
Oh, me?
Yes.
Oh, I thought the first question went to, okay, wait. What the law means to me and why I'm running?
And why are you running for the appellate court at this time?
Oh, okay. Sorry.
Oh, you're fine.
Okay, so I'm going to start with the second part first. So I am running for this position because it is an open seat. Justice McDade retired, so we have the ability to, it's a primary. And so right now on the 3rd District Appellate Court, we only have one woman. I think we need a little more representation when it comes to women. So I am running for that reason. I am running because I'm qualified. Like I said earlier, I have been practicing appellate law since law school. I had the opportunity to argue before not only the 3rd District, but all of the other district courts here in Illinois. What the law means to me probably means more to me now than it did 2 years ago. As a judge, I have seen the erosion of faith and confidence in our judicial system, in large part to the higher-ups in our country who are running it, and it's incumbent upon us as judges to restore confidence in the legal system and the judiciary going all the way to the trial court level. It is important that we as judges exercise not only following the law, but empathy. It is important to understand that there are many people who are out there who are committing crimes, who are involved in litigation, and they just don't have the skill set to properly represent themselves. We as judges have to be able to identify those people and help them. We have to have that type of outreach. We have to create those resources so that people can have access to justice, they can have access to our courts, and they can finally get their issues resolved with appropriate representation and without any form of prejudice. So I think I've answered both parts of that question. Thank you.
So as to the first part of that question, what does the law mean to me? I would suggest that the law, the rule of law, our system of justice, it's a central defining feature of what makes this country what it is. When you think about it, what are we? The land of the free and the home of the brave. Well, that's only true because the law protects us. The law protects us when we're injured. The law protects us if you've been a victim of a crime. The law protects you if someone is trying to evict you from your home. Once the rule of law no longer applies across the board equally, our system, our national way of life begins to collapse. The rule of law is, it's not just what defines us, it's what makes us admired around the world. And so I talk a lot about the rule of law. I basically center my campaign around the idea of the rule of law, because at this point, what we're seeing now, like as Judge O'Connell mentioned from the top, it's an attack. It's an attack on our system, and it's an attack on what makes us great. So the law to me is something, when it goes to the heart of being an American. When somebody asks, are you proud of being an American? What does that even mean? It means it's an idea. America itself is an idea. This country is an idea. And if that idea collapses, then we collapse. So I look at the rule of law as what it means to be an American. I am proud of our system of the rule of law. For that reason, I am proud to be an American. I'm not so proud of what's happening at the national level, though. As to why I'm running, I'm running because I believe that is where I personally can be most effective at trying to stand up for the rule of law. The trial court is, of course, important, but the appellate court is important as well. As Judge O'Connell mentioned, this is an opening, this is a primary. This position does not come along that often, that frequently. Quite frankly, I don't know if what we were seeing at a national level weren't happening. I don't know that I would run for this election. This is a lot of work. It's a lot of time. I think we can all agree on that. But what's at stake right now is so important, and I do believe that I have the qualifications. I believe I have the experience to be an effective appellate court justice, and I know that I am 100% committed to the protection of the rule of law, and essentially what it is to be an American, in my opinion. So, thank you.
And Judge Pappas, you're going to get the next question for those of you. This category is the professional experience and qualifications. Please explain why your experience makes you the best candidate. For a frame of reference, how many different firms or government agencies have you worked for? What is the duration of the services at each? And do you have private practice, government experience, or both?
Okay. Great. So, again, I touched a little bit on this in my intro, and I would suggest that I am qualified for this position. And it's not just me standing up here and saying this. The Illinois State Bar Association, which is the largest bar association in the state of Illinois, just released their judicial evaluations, and they gave me their highest rating of highly recommended for appellate justice. And that's important. That's because that's coming from my peers, from our colleagues. Those are people that know us. Those are attorneys that have been in my courtroom on a daily basis. Those are attorneys that have appeared in front of me previously. Those are attorneys that I've worked with in private practice. So I do think that rating matters. And as for my experience, I touched briefly on my judicial experience in the trial court. Again, I am going on 7 years now. And that experience has been a variety of experiences in a variety of different courtrooms. And on the appellate court, you do have to deal with all sorts of matters of law, all sorts of issues that perhaps you weren't comfortable with in private practice or as a practicing attorney, because all those cases, all the types of legal cases are going to come before the court. And so you do have to be ready to address that and hopefully have some experience. So my private practice experience, it was primarily civil in nature. As I indicated, I did focus my practice on international human rights litigation. And in that capacity, I represented clients from that were victims of various wars in the Balkans in the 1990s. I represented victims of the Hungarian Holocaust during World War II. I represented victims of illegal communist appropriation of property in the former Soviet Union. So all of that experience, it required the nature of that practice and the nature of those cases, as you can imagine, required a tremendous amount of work at the appellate court level. You're not going to sue a country and have them just hand over a check. That's just not how it works. They're going to fight you all the way to the end, and that's what happened. And because of that practice, because of that experience, I really have, I believe, become an excellent legal researcher, an excellent legal writer. I have been published, multiple articles published in the Circuit Rider, which is the Seventh Circuit publication for the Federal Court of Appeals. I have written briefing all the way up to the United States Supreme Court, and I think those skills are important for anyone who's seeking to be given the honor of working on the appellate court. Government work, I did not practice law at the government side, but I did immediately after law school. I did, as I think some of you know, I did work for the Central Intelligence Agency, and I joined the agency immediately after 9/11. 9/11 happened during our third year of law school, my third year of law school, and my wife Kelly and I did lose a friend in that attack, and so because of that, I did end up accepting a position as an undercover officer with the CIA. And immediately after leaving the agency is when I began practice. So I was in private practice for just over 14 years before being appointed to the bench. Thank you.
Okay, so I have to stand behind the table. All right, so my professional experience, again, as I said, I've been practicing law for 34 years. So when I was in law school, I was going to law school, I was working, and I did work at the Illinois Attorney General's office. I worked for the government from 1990 through 2003. During that time, I did work in the office of the Illinois Attorney General, the DuPage County State's Attorney's Office, and then I went back to the office of the Attorney General when my then boss, who was the state's attorney, became the new Attorney General. A little back and forth. Throughout that time, I did criminal prosecutions and criminal appeals. During that time, in the beginning years, from like 1990 through 1996, all I did were appeals. So I argued cases. The Attorney General here in Illinois has exclusive jurisdiction of practice in the Illinois Supreme Court. So I wrote briefs there, I argued cases there, and then in the Seventh Circuit and the District Court, because we represented, as the Attorney General, different Illinois agencies, most specifically the Illinois Department of Corrections. So in practicing the federal aspect in those early years, a lot of that did revolve around the civil code of procedure. From 2003 to 2006, I was also in, that's when I was back in a portion of that time in the AG's office. From 2006 until the time that I was elected in 2020, I was in private practice. During my years of private practice, I worked with law firms that were private, and I did municipal prosecutions, I did appeals, both civil appeals and criminal appeals. I did criminal defense, I did family law. While I was a family law attorney, in addition to representing parties in divorce cases, I also represented the best interest of the children in my appointments as a guardian ad litem, whether that be in a family law case or in a chancery case where I was representing disabled adults or disabled children, and making a determination and a recommendation to the court as to where these individuals would be best suited to reside. As I said, I have argued cases in the Illinois Appellate Court, the Illinois Supreme Court. I've also, during my tenure with the Office of the Illinois Attorney General, I did draft legislation regarding abuse of the elderly that evolved from a personal experience where one of my family members physically abused my grandparents and myself, and so I wrote, with the assistance and blessings of my boss, Financial Exploitation of the Elderly, the statute. It withstood judicial scrutiny and remains on the books today. I also was an advocate for the advancement and the inclusion in the aggravated battery statute that if you batter someone over the age of 60, which I am now, that it is a felony, and that remains on the books today. So I have a lot of experience not only practicing in the appellate courts, but also working with the appellate courts. I also wrote the amicus brief on behalf of the state of Illinois as it relates to the implementation of the sexually violent persons statute, which withstood U.S. Supreme Court scrutiny, remains on the books today, and does allow us in Illinois to file a petition to have individuals who have not engaged in therapy while in the Department of Corrections for a civil commitment at the end of their criminal sentence. And that is done in order to protect our children and to protect those who are disabled. So my time's up again. All right, thank you.
And same question.
Oh, I'm going to get this one again. I'm never going to get one.
No, it's all right.
Sorry.
No worries. This question is still in the same category of professional experience and qualifications. What specific attribute or achievement in your professional background distinguishes you from your opponent as the most prepared candidate to serve the public interest?
Okay, so it would have to be the brief that I wrote in the United States Supreme Court as it relates to the sexually violent person statute and the constitutionality of it, which we won. Because when the sexually violent, I lived that. So when the sexually violent person statute was first implemented here in Illinois by the then Attorney General, we fashioned our statute after, I want to say it was Iowa, but don't quote me on that, but it was a different state. And so we took that statute and we adopted it here in Illinois. So not only, I was uniquely prepared to write the brief and to support the statute because when it was initially implemented, the only Assistant Attorney General that traveled all around the state filing the petitions for the civil commitment was myself and one other prosecutor. So I lived it. I argued the cases in the trial courts throughout the state of Illinois. I argued the cases here in Illinois on the appellate court level, the Supreme Court level, and then we were asked, because we were successful in our original drafting, and because it withstood judicial scrutiny at the appellate court and the Supreme Court level, to support the sexually violent person statute when it was being argued in the United States Supreme Court. So I think that that would be the thing that I am most proud of when it comes to my professional career.
I believe that probably the part of my career that I'm most proud of, and probably, I would guess, what most people would think makes me most qualified for this position would have to be my work on a case actually that also went up to the U.S. Supreme Court. And in this particular case, our firm was the lead attorneys on a case representing a small American business that had won a contract to do some work in the Republic of Iraq on behalf of its Ministry of Defense. It just so happened that our client was uniquely situated to work on former Soviet bloc equipment, Warsaw Pact equipment, military equipment. So he was hired to refurbish the military equipment on behalf of the Iraqi military so that the U.S. military could stand up, if you remember that phrase, so the Iraqi military could stand up so the U.S. military could stand down. Unfortunately, as was often the case in Iraq during that time, there was a very corrupt element within the Ministry of Defense, and they ended up executing both the president of the company and our chief engineer. So we needed to find a unique solution so that we could get some justice for our client. We ended up bringing a breach of contract case under what's called the Foreign Sovereign Immunities Act against the Republic of Iraq and its Ministry of Defense. And despite the horrific background of the case, we essentially argued a breach of contract. And there were some very serious jurisdictional questions that had to be answered and addressed early on, not to mention the factual elements that we ultimately had to prove. But I, along with a professor from Northwestern University who taught international law, he's since passed away, we came up with a rather unique and ultimately successful complaint. We defended that complaint all the way up through the Fourth Circuit Court of Appeals, then it got transferred to the District of Columbia Court of Appeals, and all the way up to the Supreme Court. That was a difficult case. We had to come up with some novel theories. We faced some very significant threats while we were trying to do the investigation, but ultimately we were successful, and we were able to get some justice for our client and our client's family. So that would probably be the case that I'm the most proud of, and I do think that the work that went into that does reflect my abilities as an attorney, as a legal researcher, and a legal writer. I would also just point to two other things, not necessarily anything that I did in private practice, but I think that if you'll ask people that have appeared in front of me, attorneys or litigants, I think my temperament actually makes me uniquely qualified for this position. I treat everybody that comes into my courtroom with respect. They respect the process, they will get my respect. And I also treat them with humility. And I do think that is, again, I believe my peers would recognize that, and my colleagues would recognize that, and I think that those are important qualities in a judge. You want a judge that has the appropriate temperament, and I would suggest that I do have that as well. Thank you.
And stays with you, Judge Pavich. This is a new category. It's titled Judicial Impact and Perspective. The first question is there a case you worked on? And I know you mentioned the case as a lawyer, but as a judge that has had a significant impact on you personally or on the way you view the judicial system?
There absolutely is a case that has had an impact on me personally, and the case itself was while I was presiding over the juvenile abuse and neglect courtroom. The proceedings in that courtroom are confidential, so I can't give any names, just a very general background of the case. I was fairly new on the juvenile abuse and neglect call, and as you could probably imagine, that is a difficult call. It's a difficult call with difficult fact patterns, difficult law, and we deal with some really tragic cases. And I did have a case, and it involved a young mother with several children, and she wasn't abusing them, she was just having a really difficult time taking care of the kids and monitoring them and making sure everybody was safe. And it got to the point that the kids were found running outside in the cold weather. They weren't properly dressed. The DCFS got involved. The children were ultimately taken into custody. We worked with the guardian ad litem, the children's attorneys, the parents' attorneys. We let the process play out, and it came time where a recommendation was made by the GAL and the children's attorneys to send the kids back home. And that is the ultimate goal of the juvenile abuse and neglect courtroom. We want to reunite families. If we can't do that, we will ultimately have to go down the path of termination of parental rights. But it seemed like the parents had done what they were asked to do. They had made the changes in their home. They had made the changes in their personal lives. It seemed like this was a case that was going to be a success story. So I signed the order. I made the decision to return those kids. And one did ultimately end up passing away. So, that sticks with you. And, my wife could tell you, I came real close to walking away. But you can't do that. You have to understand that our position as judges requires us to make the best call that we can with the facts and the law in front of us. And we're not always going to get it right, but we have to do our best. And so that was the worst case that I've ever had. And I pray that I never have another one.
Okay, so I sat here and I wrote down two separate cases, but I think the one case that remains with me is a case where I was appointed as a guardian ad litem in a very contentious divorce case, and mom and dad they did not like each other, and they had two minor children. I had to go one day and pick up one of the children from school because mom and dad were in court, and the children were not going to be returning to dad's house. So I went to pick up this child, and he did not want to go with me. So what happened is that I brought the child pursuant to a court order back to mom's house. And when I got there, the police were there. They were waiting for me. And I was a little taken aback because I didn't understand what was happening. And so it ended up that the child had a cell phone that I was unaware of, and he was texting with 911, the police. And so they were ready to arrest me. And I was like, but I have a court order. The child cannot go back to dad's house. And so it was a whole big rigmarole. And then, so we get everything worked out. But about 2 weeks later, I get a notification while I'm in court that this father has stabbed mom with, I think it was a hatchet. It wasn't an axe. It was something like very similar to that, but he had attacked her with a hatchet in her driveway. And it's one of those moments where it's shocking. Like, we all should be operating under what is in the best interest of our children. Even if mom and dad are getting divorced, it's so important to let our children know that they're not the reason, they're not the cause. But to put them in the middle like that and then to try to take that other parent away from them because you're upset, because you don't want to share money or some other items of personal property was deeply upsetting to me. And then ultimately he gets charged, and so now he's out of his kids' lives, which can't be what he wanted. He wanted her to be out of his kids' lives, and his own actions put not only his children in jeopardy, but put himself in jeopardy, and now these kids are growing up without their father. And so I guess that would be the case that I would have to talk about. But I get to keep the mic now, right? All right.
Got it.
All right, let's move on to a happier topic.
Hopefully, yeah.
We'll see.
The appellate rulings often establish precedents that govern the state for decades. How do you balance the immediate necessity of achieving a just result of the litigants before you with your broader responsibility to maintain legal stability and predictable outcomes for the public?
Okay, so as we both have commented on tonight, like, we've seen such a deterioration in the concept of democracy, and we are currently, I think, at a turning point as far as our way of living is right now. So there is, at the trial court level, at the appellate court level, it is important that we maintain legal precedents, but we also have to be aware of the social changes that we as a democracy are seeing. And so to that extent, it is definitely a balancing act. We have to try to maintain stability while adapting to evolving societal views, evolving, like AI. AI is one of the topics that we talked about at our last forum. It's important for us to respect precedents and also to adapt to social changes. It is difficult to do that, but I think that we have to be clear that our interpretation of the law and the application of precedents can be altered in certain situations, but we need to be respectful of the precedents. It is also important to acknowledge that the judiciary has a role and the legislature has a role. So more of society changes will be addressed through the legislative role, and then it will come over to the judicial branch of government in order to interpret those societal changes that the legislator has made. Legislators? How about that? Have made, and whether or not it is consistent with legal precedents. So it's a balancing act, and I think that we will be seeing more and more of it in our reviewing courts, the appellate court, and of course our Supreme Court.
So that's a very interesting question, and I think my answer is going to come down to several components. And I think the most important thing to recognize is on the appellate court, just as on the trial court, we are, as judges, we are obligated to make our decisions based upon the facts and the law. And of course, the law also does include precedent. Now, at the trial court, we really don't have much room to maneuver to try to make our own precedent, although occasionally all judges, I think, will have cases that have never been seen before. Perhaps they don't know if any colleagues have ever had a case of that type. So maybe you are the first trial court level judge to make a decision on a particular case. So maybe you can make some precedent that way. But at the appellate court, obviously, you have many more opportunities to do so. And while you're trying to make a decision on a case, obviously you look at the facts, you look at the law, you look at the statute. But precedent is important. And precedent gives stability to the law. It gives certainty to the litigants, to the citizens, to attorneys. It helps them understand what the law is. And if it's an old precedent, then it's settled law. That being said, I think that we've all seen recently cases, again, at the highest level in our country, where we would disagree with some of the precedents that are being set. And I believe that if a precedent is wrongly set, it is up to the appellate court judges, if it's at the appellate court level, or the Supreme Court justices, if it's at the Supreme Court level, to correct that wrong. I'm sure many people in this room would agree that many of the decisions that we're seeing coming down from the highest levels right now, they don't seem to comport with the law, with the facts, or certainly not precedent. So there does have to be that room to readdress precedent if the feeling is that it's been wrongly decided. And I think it's important for judges to remember that first, let's try to respect precedent if we can. But second, if you're in a position, say the appellate court or the Supreme Court, where you can revisit precedent, don't be afraid to do so.
And this question is kind of similar to what you were talking about earlier, but describe your approach to cases where a strict application of the law leads to a result you find morally or ethically problematic.
Okay, another great question. Sure, and that's going to happen with every judge, whether you're at the trial court, the appellate court, or the Supreme Court. You are going to be confronted with a situation where the law and the facts don't necessarily lead to the result that you as a judge, as a person would like to go. But that's not how we're supposed to rule. That's not how we're supposed to decide based on our personal feelings or our personal history. Obviously, we all bring that to the table, but we are obligated to rule in accordance with the law as the law is written or the law has been decided by a higher court. So, yes, absolutely, I have been in a position as a judge where I have had to make a ruling that I did not like, and that personally I wish that I could have gone another way. But we have been entrusted to make decisions based upon the law, not as the law as it is, not the law as we wish it would be. As Judge O'Connell said, if we wanted to do that, if we wanted to change the law, then we should run for the state legislature. We should run for Congress. We should run for Senate. That's not what our job is. Our job is to interpret the law and apply the law to the facts of our cases that are before us. And that is necessarily going to lead to decisions that we have to make, that we're not comfortable with, that we don't like, that we may be with us for the rest of our lives. But that's the job that we've chosen.
It's all of that is true. Like, we didn't sign up for this in order to not follow the law. I can tell you that at least once a week, I wrote it down. I say that while it is true that I will disagree with the law, I have to follow it. I don't have any discretion when it comes to that. The finest example of that is there's a statutory provision that says that a judge can sign a search warrant for somebody's DNA and that they have to comply. I get people at least once a week, and they're like, yeah, so I'm not going to do it. I'm like, okay, but you are. So I don't necessarily disagree with that, but I have to enforce it. There's no other way around it. It's uncomfortable. It doesn't really, ethically, I have a problem with it, but there's no wiggle room. We have to do what it is that we have to do. It is a rare case where something comes before us as judges, irrespective of where we sit, where there isn't some sort of strong precedent. We do have now, because of the Safety Act, every once in a while I get an issue and I'm like, oh, there's no precedent, and I can say what it is that I believe to be an accurate interpretation of that statute. But that's a pretty rare occasion. We have to follow the law. That's all there is to it. So I get to keep it. Okay, let's go.
Thank you. So this is a new category. It's called the future of the court. Navigating the tension between the constitutional right to pretrial liberty and the court's mandate to ensure community safety. What do you view as the primary operational challenges or benefits of this model?
Okay, so that has to be related to the Safety Act, which is new law here in Illinois. It's not new law, it's like 2 years. So the balancing act for us as trial court judges is to make a determination as to whether or not the person is deemed to be dangerous or a flight risk, such that we cannot let them, that they have to remain in physical custody while they await trial. The balancing factors that we have to take into consideration is we start from a point of, yes, we can release them on conditional release. We just have to set rules. We have to set regulations for that. That's where we start. Everybody has assumed that, yes, we can let you out. But if the court finds that it is you're dangerous to yourself, to society, to your victim, something like that, we can hold you on dangerousness. If we find that you are a flight risk, not because you were speeding, not because you were fleeing and eluding, but because there is not a potential that you're going to come back to court, such as somebody who is in our state and has no ties to our community, we can detain you. So, can you repeat the question? So what was the second part of it?
Sure.
I'm sorry.
So the second question is, what do you view as the primary operational challenges or benefits of this model?
So that's where we start at the trial court level. Part of the issue that we have is that there is no precedence because these cases have not been through the Illinois Appellate Court or the Illinois Supreme Court. Every once in a while we get 2 appellate court districts that disagree, and then it's just a free-for-all because we really have no precedence. We can do whatever it is that we want. So we have to wait for those questions to be answered by our appellate court and then ultimately by the Illinois Supreme Court, should the Supreme Court see fit to take the case. If they don't see fit to take the case, then we have to operate under what the appellate court says. Most recently, the biggest issue that we had, which was just decided by the Illinois Supreme Court, relates to sanctions under the Safety Act, and whether or not when we sanction somebody, which we can only do if they have violated a term of the conditions of pretrial release, not a new offense, we can only sentence them to be sanctioned for 30 days. So the question becomes, do we give them day-for-day credit? I will tell you, I was the only judge in my county that said no. That cannot be what our state legislature intended. Everybody else was giving day-for-day credit, and the Illinois Supreme Court decided no day-for-day credit. So, but that was an interpretation where I had other judges in my division that were giving that credit, and we had to wait for the Illinois Supreme Court to make that decision. So I think that's the biggest struggle that we have, is we don't have precedence. We thought that the legislature was going to do a trailer bill to kind of answer some of these issues that we have coming up over and over again as it relates to the Safety Act, but they didn't. So we are just waiting for the litigation to plow through the appellate court and then see if the Supreme Court is going to take it. So that's our biggest issue at this point, I think.
Well, as to the first part of the question, I don't really have that much to add. I mean, that's the standard that we have to apply as Judge O'Connell laid out. I mean, it's really a 2-part question, and it's the responsibility of the state's attorney's office to make that case if they're seeking pretrial detention. They have to show that either A, the defendant is is either a danger to himself, the community, or to a victim. And that's a element that has to be proven beyond the charges themselves. You have to actually, the state's attorneys actually have to bring some additional evidence in. So it's not an easy standard. And then also, of course, I think a challenge in terms of the Safety Act, an operational challenge, if you will. I think a lot of the public may have a misunderstanding what the entire act is about and why it was passed. The act itself really is trying to accomplish something in terms of resolving some of the inequity that existed in our pre-bond system. And the reality was that if you got charged with a terrible crime and you had $100,000 in your bank account, you were walking. If you didn't have $50, you were sitting. And that was something I think the legislature was trying to address. Like a lot of different acts that are unique and different and a bit unusual, certainly. This idea was a bit unusual if you consider what systems are in the other parts of the country. Yeah, it's not a perfect system, but it was intended to address a real problem. And I think that we are beginning to sort of iron out some of the wrinkles in the system. I think finally we're getting to a point where we're explaining perhaps a little bit better to the public why the act exists in the first place, what the standards we as judges have to follow in making our decisions, whether to detain somebody for pretrial purposes or to release them on conditions, as Judge O'Connell indicated. So it's a work in progress. It's not always easy sitting in that courtroom. Definitely, there can be a lot of attention cast your way if you're sitting in that courtroom every day. I know from hearing from my colleagues who do sit in that call. It's a difficult call, but I do think that the act was trying to address a serious issue, and I think we're getting to the point where we're getting to a better place with the safety law.
Next question is, what is one area of the law you believe the appellate court will be most challenged by in the next decade?
Well, that's a great question. I think that really depends it depends in part on what we're seeing at a federal level. Because, as I've mentioned before, as this campaign is going on, a lot of the same rights that we have that are protected by the federal Constitution are also protected by the Illinois State Constitution and Illinois law. And I think that we here in Illinois, we sort of think that we're protected because of that, and we are to a certain degree. But we see a lot of these rights, the right to love who you want to love, the right to choose your own health care, the right to read the books that you want to read. These are rights that are, let's be honest, they're under attack at the federal level. And don't think for a moment that those same challenges cannot exist here at the state level. And it kind of gets back to what I was saying. It's why it does matter. It doesn't matter. These judicial elections matter. It matters who wears the robe. Because these same rights that we have in Illinois, protected by Illinois law, they can be vulnerable. I think 5 years ago, 10 years ago, a lot of us didn't see some of the challenges and the attacks on individual rights and our rights as Americans that were going to be effectively waged at the national level, and it happened. So let's not pretend that it's impossible to happen here in Illinois just because we're a Democrat-run state. It can happen here. And so I think some of the challenges that we may face at the appellate court in the state of Illinois, I think they may revolve around some of these issues. I wouldn't be surprised if that happens in the next 5 to 10 years.
So I think that what the appellate courts will be seeing most often in the next 10 years are issues related to the Safety Act. The numbers are just explosive when it comes to appeals that are going to the appellate court. So anytime that we detain someone, they have the right to appeal that at any time prior to their conviction. So the appellate defender, the appellate prosecutor, they have entire units that are dedicated just to these types of filings. And those numbers are high. So we have a lot of cases that go up very few that come back. But all of these issues about the SAFE Act, they're going to be coming back. They're going to be litigated, and there will have to be some ultimate changes to the Safety Act. We have seen most recently cases where, because of the amount of discovery that is available to the prosecution immediately when this person is arrested, because they get to choose when they arrest the defendant. So they'll have months and months worth of evidence. Then someone is taken into physical custody, they appear in first appearance court, and we have overworked public defenders who are representing these individuals who have to say, hold on, I can't get ready in an hour or two. So these people are sitting and they're waiting for their public defenders to get up to speed. These cases are overwhelming in the amount of evidence that a first appearance court judge is hearing and seeing, and those appeals are going forward. And so I really think that that's where we're going to see a lot of the cases and the issues. And again, they'll go from the appellate court up to our Supreme Court. And I think some of those cases will trickle up to the United States Supreme Court. But I think that's the area of law that will be most litigated.
If you could implement one technological or procedural change to make the appellate court more efficient, what would it be?
Ooh, a technological one. So I'm not the most tech savvy of people, definitely showing my age with that. I think that we have seen a change where so much of, I'm a paper person, so when you do an appeal, you've got the common law record, which is the transcripts, all the paper, all the filings, and then you have evidence, which is sometimes paper, but sometimes physical items. So all of those things are being streamlined in that they are being brought to the court through an electronic process. I think that the biggest technological change that I would make is the and it's being implemented now. I'm a little embarrassed because we do have a justice sitting here, but I do like the idea, we've seen it with the appellate court and with the Supreme Court, that they're doing more and more over Zoom, so that arguments can be heard, so that, again, we have more access to, we're allowing more access to justice. By implementing oral arguments to be heard over Zoom, we are allowing lawyers who are from all over the state, all over the country, to practice here in Illinois, and allowing them to argue their cases and be heard here in Illinois. So I guess that would be my answer, but again, I'm not the most tech savvy, so, but.
I would agree with Judge O'Connell. I think that the allowing more attorneys, especially if she said if they're from out of state, to appear on Zoom, to argue on Zoom, I think that makes sense. I'm not the biggest fan of Zoom in the trial court. I think it's difficult to take evidence, to receive testimony, to have cross-examination, direct examination going over Zoom. But I think at the appellate court it makes a certain amount of sense. And I also think that we probably need to be a little bit better at just granting access to the appellate record to members of the public. It's tricky as a lawyer to try to find a record for a case that you might be interested in. I can only imagine what it's like for a member of the general public. So I think that process can probably be improved a little bit. Procedurally, I'll just say it's a little bit getting into the weeds here. I'm not the biggest fan of what's called Rule 23. And that's a rule at the appellate court that allows the court to issue a decision that's not precedential. And I sort of feel like if you issue an opinion, then it should have some weight. So I'm not the biggest fan of that particular rule.
This is, I think this should be probably our last two questions. How are we doing with time? Is it?
We're good, yeah.
Okay, so these are the last two, and then we'll do a closing statement after that. This category is called philosophy and motivation. Both candidates are running for the Democratic nomination. What does that mean to you, and what brought you under the big tent of the Democratic Party?
Well, as I indicated in my opening remarks, I've been a Democrat as long as I can vote, and that's because my philosophy in life, my views, my positions are aligned with the Democratic Party. And it was sort of an easy decision for me when I was first granted the privilege of voting. And it was, I've certainly been in roles in the past where I was definitely maybe the only Democrat in the room. As you can imagine, where I used to work, it used to be a more conservative place, the CIA. So I was definitely a lone, outspoken Democrat in that particular room. I will say, I did convert a couple of my buddies. I did bring them over to our side. But the party is just, to me, it speaks of inclusion, it speaks of acceptance, it speaks of looking out for one another and caring for one another. And that's really sort of the philosophy that I try to keep in mind when I'm wearing the robe. I really try to treat everybody who's coming into my courtroom with respect, understanding that unless they're going to adoption court or unless they're getting married, if you're in court, it's probably a pretty bad day. So I really do try to keep that in mind. I try to approach each case with patience, with a solid temperament, because whoever comes through that court, whether it's a criminal case or a civil case or a contract case, something's happened that's brought them there. And that's a human being who's having a really rough day. And you walk into a courtroom surrounded by lawyers with a judge sitting up at the top in a robe. It's scary, it's intimidating. And so whatever we can do as judges to make it a little bit easier for people, I think that's important. And so I would say that sort of sums up my philosophy and why I'm under the big tent.
So, what brought me? I was raised this way, so I guess it's kind of a difficult question. But I can tell you that my family, when they first came here a couple generations ago from Ireland, they were unwelcome. My grandfather would tell stories about how there were signs when he would apply for jobs saying the Irish need not apply. My family was fortunate in that they went to work for the unions, which allowed them to build homes, to build families, and to really create a life here. And so without the Democrats, without the union support, my family wouldn't be in the position that they are in today, and I certainly wouldn't be here today. It's the way I was raised, it's the fiber of my being. I guess my motivation for running, I think that was part of the question, the motivation.
Well, yeah, what does it mean for you to be a Democrat? Why are you running to be a Democrat, essentially?
Okay.
Yeah.
Okay, I guess I answered that question. It really just is who I am, and it was the way that I was raised. So, do we have another question, or is that?
Yeah, there's one more.
Sorry.
Oh, you're fine. So the last question for tonight, regardless of the primary results, will you commit to supporting the Democratic nominee for the appellate court, and what specific qualities or commitments would that candidate need to demonstrate to you to earn your public endorsement?
And we've talked about this all night, but we as Democrats are really the only party in our country that believes in democracy. So it's a privilege to be able to go and pull a primary ballot and have a contested primary. So yes, no matter who wins the primary, I will support, myself, okay, but of course I will support John. It is important that we understand that the person that we elect in March is going to be our candidate and will be taking on whoever the other side elects. They have a contested primary as well. So yes, of course, and that's true for any other contested Democratic race. I think that it is important that we understand that while we are all under one tent, we can have different booths for different candidates, But at the end of the day, irrespective of who is in the winning booth, we support that person, irrespective of what happened prior to the primary vote. And I will say, the two of us are not only committed, I'm sure that John is going to stand up and say the exact same thing, but we are also committed to the idea of being above boards with our primary race. And certainly, he's never said anything bad about me, and I'm not going to say anything bad about him, and that would never change after March 17th.
Yes, well, like Peggy said, I plan to vote for myself. I'm still working on my wife. I don't know. Early voting starts tomorrow, so I'm running out of time. The answer, of course, is yes. And if I'm not successful, if Peggy moves on, yeah, of course I'll support her. And I've said it before, I'll say it again. I think whoever's on the other side, it's not even close. Right. Peggy she's a good judge, she's a good lawyer, she's going to do a great job. So, absolutely.
And I will do a 3-minute closing statement. I think Judge Pavich went opening first, so why don't we have Judge O'Connor do the
Okay.
first, yeah.
All right, so this was I think this was a really good forum. Some of the questions were very insightful. I think that you saw both of us kind of struggle with our answers because we're both very thoughtful. And so I am here tonight. I think that this has been a great discussion. I am hoping that through the questions and the answers that were given tonight that I have earned your vote. It is important to understand that when we go to the ballot box and vote on March 17th, that we need to vote for the candidate that is most qualified and is also electable. That person has to be electable in order to win, not only on March 17th, but also in November. And to that extent, I believe, and you've heard my qualifications tonight, I have extensive experience in the Illinois Appellate Court. I have extensive practice in the federal courts, so I think that I am qualified. I also am electable. In 2020, when I ran, I was the first female and the first Democrat to run as an attorney and win. There were 4 judicial races on that night, and I am so grateful and so thankful. My race was the only race that was decided that night. Everybody else had to wait those 2 weeks. Now, you'd have to put me in a coma. I couldn't have done it. But I was the highest judicial vote getter in DuPage County history. So I think that I have the qualifications, and I think that I'm electable. And I think that if you vote for me in March, we'll be strong, and I am the candidate that can win in November as well. So I'm asking for your vote tonight. Thank you.
So first I do want to thank again the Frankfort Township and New Lenox Township Democrats for organizing and hosting this event tonight. I think I agree with Peggy. It's been very helpful, very constructive, and I hope you'll all agree. And I want to thank all of you for coming out here tonight on a Wednesday night. It's a cold night. I'm sure you had other places you'd rather be. So thank you for being here and participating in this. I'm going to do something a little bit unusual with my close here tonight. I'm going to tell a story. I don't ordinarily do this, but I think it's helpful for you to sort of have an insight into who I am and why I'm getting in this race. And I think it's important. It's important for you to know who your candidates are and why they're running. And so this story happens to go back, it's over 20 years, it's about 22 years ago now. I was still working and running around in the Balkans. And I was in Belgrade, which is the capital of present-day Serbia and Yugoslavia. And it had been suggested to me that I meet with a member of it was a new student protest movement that had just basically been organized. This was during the time that Yugoslavia was under a vicious dictator, probably one of the worst dictators since the Soviet Union fell. And this leader of this student movement had agreed to meet with me. And so I went to a cafe in Belgrade and we sat down we started talking, and I was struck because this guy was a couple of years younger than I was at the time, and I was in my 20s. And he looked like he was about 70. His hair was turning gray, he had no teeth, he walked with a limp, his arm was crooked. And as our meeting went on and he opened up a little bit, he eventually explained to me what had happened to him. This is something I've been thinking about a lot lately. And he told me that he had been protesting with fellow members of his group. This group is called Outpour, which in English means resistance. And they were protesting against the Milosevic regime. And they were peacefully walking down the streets of Belgrade when unmarked cars pulled up alongside. Men in masks jumped out, threw him into the van, whisked him away, took him to the basement of a windowless, nameless building, and he was held there for 3 days, tortured. And they let him go after 3 days, and they told him, consider this a warning. You don't back off, it will get worse. And the young man is telling me this story, and he's chuckling. I said, what is so funny? And the guy said, it's funny that they thought that they could get us to stand down just by trying to scare us. Because what we're fighting for is a lot bigger than that. And I said, well, what is worth this? And I'm thinking, this guy's going to be dead in a few days. And he said, we're fighting for what you already have. Because you have set the example for the world. You have shown us that it's possible to have a country that respects the law, where the powerful are held to the same standards as the weak. And if you can have it, why can't we? I left that meeting thinking this poor kid would be dead in a couple of days. But you know what happened? Less than a year later, he, along with tens of thousands of his fellow young people, marched in the streets protesting yet another stolen election by the same government. And within days, despite the brutal attempts by the government to put it down, that government fell. Their days were over. And the inspiration for that movement, and for so many similar movements around the world, is us. It's our system of the rule of law. It's what we have shown to the world, and now it's under threat, and I think we are all obligated to do whatever we can to push back. I believe as a judge and a lawyer, I can do that most effectively in the appellate court. And so that is why I'm asking respectfully for your consideration as we begin early voting. But I think we all have to ask ourselves what we can do, because we can't let this go. So thank you again for the opportunity to be here. It's been a pleasure, and look forward to the next 8 weeks, 6 weeks, 6 weeks. Thank you.